Hello everyone, welcome to Courts Today by Live Law, your go-to source for the latest and fastest legal updates. I'm your host Urvashi Chauhan, here to bring you daily developments, landmark judgments and significant rulings from the world of law. Let's dive into the headlines and quickly recap the most important stories. After that, we will break down each case in detail. The Supreme Court has dismissed telecom companies' curative petitions against ruling on AGR dues. Regarding the emergency movie Row, the Bombay High Court has directed the CBFC to decide on release by 25th September. During a mentioning regarding the judges' appointments case, the CJI today informed the Attorney General that the state of Jharkhand had filed a contempt against Union for not appointing the High Court Chief Justice. The Apex Court has expressed surprise at an anticipatory bail granted in NDPS case and called for its reconsideration. The top court has allowed candidate with speech and language disability to pursue medical education. The Supreme Court has directed State of West Bengal to form Municipal Building Tribunal within 2 weeks and asked the High Court to initiate contempt proceedings on default. The Delhi High Court has remarked that Delhi is of migrants and benefit of reservation to any category cannot be denied. The Karnataka High Court has quashed criminal case against Union Minister Shobha Karandlaje for remarks on Rameshwaram Cafe blast. The Delhi High Court has sought Puja Khedkar's response on UPSC's plea alleging perjury in anticipatory bail case. In a significant development, the Supreme Court has dismissed curative petitions filed by telecom companies including Vodafone Idea, Bharti Airtel and Tata Teleservices against a 2019 ruling of the court regarding payment of adjusted gross revenue or AGR dues. To give you a short background, in a setback to telecom companies, the Supreme Court in October 2019 had allowed the centre's plea to recover AGR of about 92,000 crores from them. The court had upheld the definition of ADR formulated by the Department of Telecom. The telecoms then filed review petitions against this decision, but the same were dismissed. Then in September 2020, the Supreme Court passed an order requiring the telecom companies to pay their AGR dues over a period of 10 years. It was clarified that there would be no revaluation of the AGR dues and any default would be met with imposition of interest, penalties and contempt of court charges. 1 year later, the court dismissed a plea seeking corrections in the AGR dues demand, with telecom companies claiming that there were multiple errors in the computation. Last year, the telecom companies filed curative petitions against the court decision dismissing the review petitions. They argued that Department of Telecommunications committed grave errors in computing the final demand. For instance, the department had raised a demand of around 58,000 crores in case of Vodafone, whereas the company's own assets was of around 21,000 crores. Appearing on behalf of Vodafone, senior advocate Harish Salve had said that the company was looking to raise debt funding to pay its dues, but potential lenders required clarity on the company's exact liability. The bench comprising CJI D.Y. Chandrachud, Justices Sanjeev Khanna and B.R. Gawai has now held that no ground was made out to exercise curative jurisdiction. In an interesting development, co-producers of the film Emergency starring BJP MP Kangana Ranaut have accused the ruling party of blocking the film's release. During a hearing before the Bombay High Court, senior advocate Venkatesh Dhund, representing Z Studios, claimed that the Central Board of Film Certification is delaying the film at BJP's behest to safeguard its overall interests. The film, which has drawn criticism from the Sikh community, is alleged to portray a polarizing leader. Dhund argued that the board is holding off certification, aiming to push the film's release until after the Haryana elections in October. During the hearing, the bench was irked to note the submissions of Dr. Abhinav Chandrachud, who appeared for the Film Certification Board, when he submitted that the board is yet to take a final decision on the film's certification and that the chairman has now referred the issue to the revising committee of the censor board. The division bench of Justices Burgess Kolabawala and Firdosh Puniwala expressed concern over the board's conduct, questioning how a film could be judged without being watched. The judge emphasized that objections to films without valid reasons threaten creative freedom and the right to free speech. The court has directed the CBFC to make a final decision on the film's release by 25th September, pushing the board to either approve or block the film. In July, the Supreme Court Collegium had made recommendations for appointment of Chief Justices of 8 High Courts. However, the resolutions still remain pending with the Union government. Last week, when the court was hearing the petition seeking judges' appointments, the Attorney General R. Venkataramani had told the court that he wanted to share some sensitive information regarding the Collegium appointments. And so the matter was adjourned till 20th September, that is tomorrow. Today, the Attorney General mentioned this and requested for adjournment that the matter not be listed tomorrow. He indicated that the centre's decision on the pending collegium resolutions was likely to happen soon. However, noting that the list for tomorrow is already published, the court suggested that the AG can make a mention tomorrow when the petitioner is also present. The CJI also informed the Attorney General today about the contempt petition filed by State of Jharkhand against the centre for delay in appointment of Chief Justice of Jharkhand High Court. AG replied that he was not aware of the petition. The matter is listed tomorrow. Stay tuned with us for more updates. In another update, the Supreme Court today expressed surprise at grant of anticipatory bail in a case under Narcotic Drugs and Psychotropic Substances Act of 1985. In this case, the narcotic substances were allegedly found in possession of an accused person in the scooty, and he had named the other co-accused who were granted anticipatory bail. Advocate Abhijit Sen Gupta requested bail for the accused on parity with the co-accused who have already received bail. He informed the court that in addition to 4 accused who were given anticipatory bail, 1 other accused has been granted regular bail by the High Court. He also pointed out that the accused for whom he appeared had already been in custody for around 11 months now. The bench of Justices B.R. Gawai, Arvind Kumar and K.V. Vishwanathan remarked that grant of anticipatory bail in an NDPS case was unheard of and a serious issue. It has directed the state of West Bengal to consider filing applications seeking cancellation of the pre-arrest bail granted to the accused. Let me tell you, anticipatory bail is generally not granted in NDPS cases due to the seriousness of the offences relating to drug trafficking and possession. The law under NDPS Act is quite strict, and Section 37 of the Act imposes stringent conditions for bail, especially when the commercial quantities are involved. And now let me tell you, the Supreme Court has allowed a candidate with nearly 45% speech and language disability to be admitted to MBBS course after a medical board opined that he could pursue medical education. The petitioner here had initially approached the High Court challenging the Graduate Medical Education Regulation of 1997 framed by Medical Council of India. According to this, persons with equal to or more than 40% disability would not be eligible to pursue MBBS course. The petitioner contended that the regulations were contrary to Right of Persons with Disabilities Act and ultra vires Articles 14, 15, 19(1)G, 21 and 29(2) of the Constitution. He submitted that though he did not suffer from any functional infirmities or disqualifications which would have caused hindrances in completing his education, his admission seat had been cancelled as he suffered from speech and language impairment of 40 to 45%. But the High Court denied him relief, prompting him to approach the Supreme Court. Earlier this month, the top court had constituted a medical board consisting of specialists to examine whether the speech and language disability of the petitioner would come in his way in pursuing the medical degree. Following the positive report given by the board, the court allowed him admission. The bench of Justices B.R. Gawai, Arvind Kumar and K.V. Vishwanathan has directed that the candidate be admitted to the seat which was earlier directed to be kept vacant. It orally stressed the need for a more flexible and sensitive approach towards allowing medical education for persons with disabilities. The Supreme Court has directed State of West Bengal to complete formulation of Municipal Building Tribunal within 2 weeks, warning that failure to comply could lead to contempt of court proceedings. Under the Kolkata Municipal Corporation Act of 1980, any party aggrieved by a demolition order for unauthorized construction can appeal to the Municipal Building Tribunal within 30 days. A bench of Justice Suryakant and Justice Ujjal Bhuyan noted that the state of West Bengal has appointed a chairperson for the tribunal but has not yet appointed judicial and technical members, rendering it non-functional. The court was dealing with an SLP by the custodian of enemy property for India regarding demolition of unauthorized constructions on an enemy property in Kolkata. For those of you who do not know, let me tell you, enemy property is property that belongs to individuals, entities or organizations that are considered enemies of the state. This includes property left behind by people who took citizenship of Pakistan and China after partition of British India and conflicts with neighboring countries. The top court has directed the concerned authorities to ensure that unauthorized constructions are immediately demolished and directed the aggrieved parties unable to file appeals against demolition orders due to delay informing the tribunal to approach the Calcutta High Court for relief. The court requested the Chief Justice of the Calcutta High Court to list all related matters before his division bench to avoid conflicting orders. The tribunal, once fully constituted, has to prioritize appeals related to demolition orders. In an important update, the Delhi High Court has held that national capital, being a union territory, is of migrants and benefit of reservation to any particular category cannot be denied. The court made these observations while dismissing an appeal filed by Delhi Subordinate Services Selection Board against an order of Central Administrative Tribunal. The order had held that one Vishnu Kumar Badetia was entitled to appointment on the post of staff nurse with the Delhi government's health ministry as an SC candidate pursuant to advertisement published in 2009. He was declared successful in 2011, but his name was not mentioned in the final list. He was informed by the authorities that his candidature was not considered under reserved category as the caste certificate provided by him was issued by state of Rajasthan, which is other than Delhi. He contended that as per a letter issued by the Delhi government, the SC/ST candidates, irrespective of their nativity, shall be eligible for reservation to the civil posts under the GNCTD. On the other hand, the authorities argued that during the period from 4th August 2009 till 12th September 2012, the benefit of reservation to SC/ST category candidates who were from outside of Delhi in respect of civil posts under the Delhi government was not extended in view of a decision of the Supreme Court. It was their stand that granting benefits of reservation on pick and choose basis to outside SC/ST candidates in respect of exams conducted and results declared during the period in question will unsettle the entire recruitment process in a number of cases. The bench noted that candidates belonging to economically weaker sections category, irrespective of their state from which they belong to, are given appointment in Delhi. It said that in such a situation, the state of NCT of Delhi is giving reservation to one category and denying to the other category, which is sheer discrimination and cannot be permitted. Therefore, dismissing the appeal, the division bench comprising Justice Suresh Kumar Kaith and Justice Girish Katpalia observed that NCT of Delhi, being a union territory for all purposes except for running administration, is of migrants. Therefore, benefit of reservation to any category cannot be denied. The Karnataka High Court today quashed criminal case registered against Member of Parliament Shobha Karanlaje after she had made a statement during a protest in Bengaluru, linking the suspect in Rameshwaram cafe blast with Tamil Nadu. During a protest against an attack on a shopkeeper in Bengaluru, she had said that law and order in Karnataka had deteriorated. People who come from Tamil Nadu plant bombs here, people from Delhi chant Pakistan Zindabad slogans, and people who come from Kerala are involved in acid attacks. After this, cases were registered against her under Representation of People's Act. The petitioner had argued that reading of the alleged offences does not indicate that it is prima facie an election offence, as the purpose must be either promoting voting or against voting for some candidate. A single judge bench of Justice M. Nagprasanna allowed her petition and quashed the proceedings, noting that Madras High Court has recently quashed similar proceedings against her, which sprang out of the same incident. And lastly, the Delhi High Court today issued notice on a plea moved by Union Public Services Commission alleging that former probationer IAS officer Puja Khedkar committed perjury by filing a false affidavit and making a false statement in relation to her anticipatory bail plea. Justice Subramaniam Prasad has now sought the response of Khedkar, who is accused of misrepresenting and falsifying facts in her UPSC application. The matter will now be heard on 26 September. If you remember, on 31st July, UPSC cancelled Khedkar's candidature and debarred her permanently from all future examinations and selections of the commission. She has been granted interim protection from arrest, which continues to date. In its application, UPSC has alleged that Khedkar, in her counter affidavit to the anticipatory bail plea, made a false statement that the commission had collected her biometrics. UPSC has rejected the claim, arguing that the commission did not collect any biometrics or any biometric information from any candidate during the personality test of civil services examinations held so far. The commission has further alleged that Khedkar made the false statement with the sole aim and purpose of deceiving the court for obtaining favourable orders. The matter will now be heard on 26 September. Stay tuned. For detailed insights on the cases discussed today, head over to our website at www.livelaw.in. Stay informed with real-time legal news only on Live Law. Make sure to like, share and subscribe to our channel for regular updates. You can also show your support by using the thanks button below our videos or by becoming a member for just 89 rupees per month.